Welcome back from lunch, everybody, and hope we'll get this afternoon session off to as exciting a start as we had this morning. We're going to have a keynote address from Dr. Ula Cartwright-Finch in a moment, and I also want to advise you to stick around after her presentation because we'll have a second portion of our program today, a panel on the legislative changes that have happened recently in the UK and in British Columbia, and get a sense of how those changes have affected arbitral practice. And the reason TCAS is interested in that is because we have our own process in place looking at changing the Ontario legislation, so we thought this would be a great opportunity to find out what's happened in a couple of other common law jurisdictions. But let me turn to our keynote speaker, Dr. Ula Cartwright-Finch. Ula is the founder and managing director of a company in London called Cortex Capital, but she's also International Arbitration Counsel. But she left international arbitration to pursue her real love of cognitive neuroscience. She did complete her, being the overachiever she is, she completed her law studies and her PhD at the same time, and then went on to work at Herbert Smith in London and Hong Kong with Donnie. She then was at Linklaters in Madrid and London, and in 2019 founded Cortex. Cortex provides training to law firms, financial institutions, and corporates on topics such as witness preparation, interviewing, memory, cognitive bias, negotiation, DEI, and decision-making, as well as doing research. And what we're going to hear from Dr. Cartwright-Finch today is the outcome of some of her recent research on how tribunal decision-making really works. So, without further ado, Dr. Cartwright-Finch.
Self-conscious after Barry's talk that I'm brandishing paper, but I only printed it once. Now, I know we are in the infamous post-lunch dip, very real, much documented, where our brains just want a nap, not a keynote. So I promise to keep things spicy enough to keep us all awake. So let me start with two questions. I think we'll have some slides at some point, but I don't need them yet. So first, how do tribunals actually think? And secondly, can we redesign tribunal deliberation to promote better decisions? Now, a lot has been written about cognitive bias in international arbitration, covering things like confirmation bias, recency bias, overconfidence. And cognitive glitches like these are critical to be aware of if we want to improve our own thinking. But the conversation usually stops there, at the level of the individual, which assumes that each arbitrator is its own or their own sort of discrete and self-contained decision maker. But most arbitral awards are not written by individuals. They're produced by groups of individuals, usually panels of 3. And that changes everything. So today I want to offer a different lens to look at decision-making in international arbitration, not at the level of the individual, but the more complex, the dynamic level of tribunal cognition. So how tribunals think, feel, influence, and decide as a group. Now, according to a recent study, 78% of people want the bad news first. So for most of us in the room, here it is. Group decision-making might sound like a fair, sort of democratic and rigorous process. But psychology tells a more complicated story. And there are two particular hazards that I want to highlight here. The first is groupthink. So this is a classic psychological phenomenon where a group's desire for harmony leads it to make a consensus decision that is made without thorough or complete evaluation, and often results in an irrational or a flawed or an inadequate outcome. Now, according to Irving Yannis, the Yale psychologist who pioneered this research, the main factor that contributes to whether or not groupthink is going to happen is the degree of cohesion, the amiability, or what he called esprit de corps, within the group. So that is the feature that leads individuals to prioritize maintaining friendly relationships and to avoid conflict over raising controversial ideas or show independent thinking. Now, there are several side effects of groupthink, but most relevant in this context, we have three things. First, the illusion of invulnerability. So this gives tribunals an inflated sense of certainty that their decision is the right one. So it's basically overconfidence at a group level. Also, self-censorship can occur, where individuals withhold from expressing dissenting views or from questioning the prevailing decision. And then there is the illusion of unanimity, where silence from individuals is wrongly perceived to mean that they agree. Now, these symptoms can have fundamental, sometimes disastrous consequences, and a classic real-world example of groupthink is the Space Shuttle Challenger disaster in January 1986. Now, there was intense media interest in this particular launch because it was going to be the first one involving a civilian crew member, a school teacher. So NASA project leaders were under even greater pressure than usual, and in particular not to delay the launch. But weather forecasts were predicting record low air temperatures for a shuttle launch. -8 Celsius overnight and -3 at the time the shuttle was due to launch. And you could actually see a lot of ice on the shuttle in the morning it took off. That was a problem. So the engineers who worked on the solid rocket boosters, the two big rockets either side of the shuttle, they were concerned that the cold air would impact the resilience of the booster's O-rings. Now, I'd heard about O-rings before, they sound quite small, but actually they're massive rubber rings, 38 feet in circumference, that connect the bits of the solid rocket boosters together. So they seal the joints and keep the rocket intact. Now, the evening before the launch, the engineers voiced their concerns to the NASA project team, recommending that the launch is delayed until the temperatures increase to over 12 degrees Celsius, which is the temperatures where the O-rings had been tested. But with the backdrop of the media pressure, NASA pushed back heavily against the engineers' concerns. And eventually, the engineering firm's leadership relented and gave the green light. Now, 73 seconds after blastoff, that O-ring seal failed on the right solid rocket booster, causing hot pressurized gas to leak into the joint and then hit the external propellant tank. The orbiter was blown apart and all of the crew members died. So groupthink here means that NASA's strong desire to achieve a consensus, to get everyone to agree, to give that green light, and to delay under that time pressure, overrode critical safety concerns. Now, there are several potential mechanisms that operate to produce groupthink. Deferring to others' preferences in order to preserve harmony, that's a really big one in arbitral can be a really big one, or to retain social capital. Failing to share knowledge that one individual might have, underweighting dissenting voices. There's something called social loafing, where just because you're in the group, you do less work, you kind of exert less independent thinking. Now, given the culture of international arbitration, I won't mention social loafing, but the strong social network element, the camaraderie, and the pressure that some arbitrators, maybe perhaps newer arbitrators, might feel to preserve future appointment opportunities, means that groupthink is one of the most significant risks to be aware of in tribunal decision-making. Now, the second hazard in tribunal psychology is group polarization. Now, this refers to the tendency for group discussions to lead members to adopt even more extreme positions on an issue than they held originally as individuals. Now, interestingly, polarization is a much greater risk where groups are newly formed, like arbitral tribunals, and where they're undertaking new tasks, like undertaking a novel decision. So again, highly relevant for arbitral tribunals. And unfortunately, group polarization has been found alive and well in many legal contexts. So jury studies, for example, show that after deliberating together, mock jury members often decide on punitive damages awards that are either larger or smaller than the amount the individual juror had favoured before the discussion. So where jurors favoured relatively low awards, discussion would lead them to an even smaller result. And by contrast, if the jury was inclined to impose a stiff penalty before the deliberations, discussion would make that even harsher. Now, another classic study conducted in 1973 looked at whether federal district court judges in the US made different decisions when they were sitting alone compared to when they were sitting in small groups. Judges in this study were given a hypothetical case involving a challenge to the constitutionality of a statute or a government policy, and the judges effectively had to choose between a cautious course of action, upholding the statute or policy, or a more extreme one, striking it down and declaring unconstitutional. Now, when sitting alone, judges opted for the extreme action about 35% of the time. But when they sat in panels of 3, that figure jumped dramatically to 65%. So we know from studies like this and many others that even highly trained legal minds are not immune to group dynamics. In fact, group settings can actually significantly increase the likelihood of incomplete or extreme decisions. Now, there are a few mechanisms at play in group polarization, but primarily it happens because individuals become more convinced of their own views when they hear other people sharing their own views that match, perhaps new and even more persuasive arguments supporting them. And relevantly, again, for tribunal cognition, this sort of informational influence is especially strong in discussions involving complex and intellectual issues. So that's the bad news for tribunal cognition. And now the bit you've all been waiting for, the good news. Now, research shows that under the right conditions, groups can be smarter than any of the individuals in them. This is similar to the wisdom of crowds effects, which you might have heard of, and it's the promise of a relatively new area of science called collective intelligence. Now, the seminal study on collective intelligence was published in 2010 by a group of MIT researchers led by Anita Woolley. They wanted to know, is it possible to measure the intelligence of a group of people in the same way that we measure general intelligence of individuals, so IQ? So they took 192 groups of people and gave them various problem-solving tasks, like brainstorming together, making collective moral judgments, negotiating. And they looked at the results of all of those different tasks from all of those groups, and using factor analysis, they found that each group did have an identifiable, measurable C factor, which explained all of the test scores, or correlated closely with the test scores, and it could accurately predict how those groups would perform in future tasks. So that is collective intelligence, or CQ. Now, naturally, they wanted to know what led to higher CQ. So what produces a group of very intelligent people? And interestingly, variables you would have thought might have made a difference don't. So there was no correlation between a group's collective intelligence and its motivation levels, its satisfaction levels, even team cohesion. They were not correlated. There was also only a weak correlation between a group's collective intelligence and the intelligence of individual members within that group. So that means that you can have a group of highly intelligent individuals who perform horribly as a team, and you can also have a group of average intelligent people who will outstrip the Mensa members on collective tasks. There was another surprising finding in this research that I want to share with you, and that is that what they found, plotting collective intelligence along the side and the gender makeup of the groups, is that the more women in the group, the more intelligent the group performed. Though there was an interesting drop-off for all women teams, for which I have my own untested theories. Now, in case the cognitive drawbridge has started to raise in approximately 2/3 of this room, there are some important caveats. So first of all, as I said, the gender effect drops off for all women teams. So groups need gender balance, they need gender diversity to function optimally, and that is important. More fundamentally, though, it isn't actually gender itself that mediates collective intelligence. Further analyses were done on all of the groups, and what the researchers found is that the key variables that predict collective intelligence are turn-taking, so conversational turn-taking. How often did people take turns to talk? Was everyone included? Did everyone get an opportunity to discuss? And relatedly, social sensitivity. And this was measured in a really difficult test where you're given a pair of eyes and you have to guess which complex emotion that pair of eyes is telling you. And the thing is that in general, women score more highly on that test of social sensitivity. So whilst there was an unexpected gender effect, it was really explained by the level of social sensitivity that women tend to be higher at. So what this means is that a group of socially sensitive men will perform just as well as the almost all women teams on that graph. What this research on collective intelligence shows is that it's not just who's in the tribunal, but how they interact that determines the quality of the functioning. And this brings us to cognitive diversity. So cognitive diversity reflects differences between individuals in their knowledge, in the way they approach things, in their actions, in their processes within a group context. Now that is distinct from, but may stem from, demographic differences like gender or ethnicity. And in general, studies find that when groups include diverse thinking styles, they perform better, and especially on complex tasks. So all of this research is highly applicable to arbitral tribunals who are doing novel, complex, informationally deep decisions. One study looked at how groups approached solving a classic logic puzzle, the Wasson card sorting test, and for your own entertainment, I have it here. So you have 4 cards in front of you, 2 letters and 2 numbers, and your task is to decide which card or cards should you turn over to test the rule that all cards with vowels on one side will have an even number on the other side. Now, the beautiful thing about this test is that it leads you to an intuitive but wrong first answer, and people reliably pick this answer, which is you want to turn over 1 even number and 1 vowel. The right answer, I might actually leave you to work out over coffee. You can compare notes, but it's not that intuitive one. Anyway, the researchers took data from 500 small groups who completed that task. And what they did is analysed in detail the conversational transcript of the discussion that happened between those groups and compared the group's initial answers, so before having the discussion, with what they thought the answer was after their discussion. And what they found is that greater cognitive diversity, which they measured by a few different factors, so group size, or the diversity of initial ideas expressed, or the diversity in the discussion content itself, cognitive diversity consistently led to more successful group deliberations and better decision making. And I have heard of several anecdotes from arbitrators that I know of panels that they've been on where diversity is greater, and that has produced longer and trickier deliberations, but unanimously, all of them have said the award was more robust and more thought through as a result. So cognitive diversity, better decisions. There is important nuance here, as there always is when talking about psychology and people. Too much diversity can hamper group function, particularly where it facilitates conflict or where it gets in the way of agreement on common goals. So one study looking at cognitive styles, which is the way that team members encode, organize, and process information, found a curvilinear relationship, so an inverted U shape, between the degree of cognitive diversity along the bottom axis there and its collective intelligence. So too little diversity, not a great deal of intelligence. Too much diversity also hampered intelligence on these tests. So there may be a Goldilocks degree of diversity, of difference, but difference is essential for optimal group intelligence and optimal group decision making. Now here's where neuroscience actually adds something quite exciting. Now, something called hyperscanning is a relatively new method where researchers scan multiple brains at the same time. So brains are actually interacting with one another in real time. Now, usually, individual brains operate in their own unique way. The sort of electrophysiological brain waves, that is the rhythmic pattern of electricity that neurons emit, will look different when you compare independent brains operating and you put them side by side. But recent hyperscanning studies show that when people cooperate efficiently and effectively, their brains literally sync up. So the brain waves fall in line such that neural synchrony increases in well-functioning groups. And that synchrony correlates with and actually can reliably predict better collaboration, better decisions, and even greater trust. So in other words, thinking together and collaborating and deciding together isn't just a metaphor, it's actually biological. So the cognitive assets of a tribunal, its intelligence, its diversity, are important considerations with real neural implications for the way they will behave as a group. So how do tribunals actually function? What's going on? So I want to talk briefly about some invisible dynamics that shape group deliberation. Now, these are little talked about because they're really hard to pin down, but they are also the most powerful forces that shape interpersonal dynamics, like those within international arbitration. So first, empathy and trust. They're the bedrock of any constructive group work, but they are fragile, and particularly so in culturally diverse panels. Now, neuroscientific studies show that when people feel understood by others in a group, their brains become active in reward-related areas. So the areas that are usually active when we're eating, or we win the lottery, or take recreational drugs, so reward pathways become activated when we are understood, when we trust each other, and we're being listened to. Conversely, when people feel misunderstood or excluded, you see brain activity in the areas of the brain responsible for social pain. And fascinatingly, that is the same brain area or the same network of brain areas that code physical pain. So empathizing with tribunal members is fundamental to effective functioning. But if you think about tribunals and international arbitration, you have a lot of differences to navigate. You might have different cultural backgrounds. You have intense time pressures. You might have language barriers or conflicting legal backgrounds. Now, that can be a tough environment for empathy, and something which may need deliberate and sensitive work to develop. Then we have personal influence dynamics. Now, many factors influence our influence. Status and seniority, so whether you're the chairperson or the wing, will have a massive impact on your impact on other people in the tribunal. Confidence is important, so it's not what you say, it's how you say it. And again, that's something which varies among cultures. So we have different cultures have different variations in how confidence is expressed and also perceived. Something as apparently benign as who speaks first can also make a huge impact to influence within a group. So jury studies which analyse patterns of jury deliberation find that in 90% of cases, 90%, the verdict that is initially discussed in the beginning is ultimately the one that's decided on at the end. So think carefully about who is speaking and when they are speaking and what you are taking from that communication. And finally, we have in-group bias. So this is where we unconsciously favour, we like, we listen to people who we identify with and unconsciously ignore or downplay or critique ideas from those we don't identify with. Now, identity here can be very broad. It could be something obvious like gender or age or ethnicity, but it might be something like shared background or native language or the law firm you trained in, or it could be even something as trivial, or I should not say as trivial, as liking a hockey team. If you reflect on your experience at this conference, who have you spent most of your time so far talking to? Is it people who are very similar to you? Is it people of the same gender as you, the same age bracket as you? These are very, very powerful forces which impact who we choose to spend our time with and who we listen to, and these translate very closely into who we're persuaded by on arbitral tribunals. So these invisible dynamics operate in any social interaction. So the same principles apply in any group setting you are thinking about. But in this context, all these things show us that tribunal deliberations aren't just a clean debate among rational actors. They're a complex dance of emotion, of identity, and of influence. So what do we, this is an excellent example of in-group formation, very naturally, in any context. So what do we do with all of this? Now, luckily, armed with relevant insights from psychological science, we can design tribunal culture to improve cognition and decision-making within a group, within a tribunal. And practical strategy should start at the beginning with appointments. So we should look beyond identity and appoint for cognitive diversity, knowing that that difference is the one that unlocks optimal performance. So yes, gender, nationality, legal tradition, all of those things matter. But so do experience, diversity, thinking styles, and even temperament. Is this someone who asks questions or makes statements? Is it someone who changes their mind or who rarely changes their mind? So these things are really important. Tribunals can also take a more organized and structured approach to deliberations, encouraging turn-taking, systematically making sure everyone is heard on all of the issues, and ensure that you have heard and really heard from everyone. So communication, not just of opposing ideas, but of knowledge that others might have missed, is repeatedly found to be the critical factor in people making effective decisions. So communication is, as ever, key. Relatedly, the chair should avoid giving their view first. So chairs are often more senior, more experienced, as a result, perhaps more confident, but the natural status of the role will also serve to anchor everyone's subsequent discussions, all of their subsequent thinking. Newer arbitrators in particular might feel uncomfortable disagreeing with a senior experienced chair, regardless of how preliminarily they said their view was expressed. Individual arbitrators can also be assigned the specific role of devil's advocate, and perhaps different devils for different issues. Now, the best devil's advocacy is where it arises naturally. So where people actually genuinely disagree, that's always the best form. But in the absence of that, or in case a tribunal all naturally agrees with one another, this formal role can ensure that the prevailing view, the naturally landed upon answer, is adequately stress tested. Another idea is to invite written reflections from each member of the tribunal before oral deliberations begin. That can help ensure that individual perspectives are formed and independently considered before hearing from other people in the group, reducing that risk of groupthink, premature consensus, or of those dominant voices having too much of an influence. Now, these procedural designs aren't gimmicks, they are well-founded methods of scaffolding better cognition, of helping a tribunal think more effectively as a collective. So we should really be thinking of tribunals as cognitive ecosystems, so systems that generate their own decisions, their own cognition, and systems that can be tuned and supported. So in the spirit of this theme's conference, one good idea, here's mine, consider tribunal intelligence. So this idea that each tribunal, each group that you operate within, will demonstrate different degrees of collective intelligence, depending on the various factors that we've talked about. With that in mind, if we want better decisions, we can't just focus on evidence and procedure. We need to support the way tribunals think as a collective mind. So the challenge and the opportunity is to engage in conscious deliberation design to promote tribunal intelligence and better decisions. Et voila. So in the spirit of conversational turn-taking, shared information, and inviting all communication, I will give you all the floor and rely on Doug to keep us in line on time. So thank you very much. Yeah, hi. Oh, do we have a mic?
Engaging in discussion. Todd, please.
Hi, I'm Todd Weiler. I'm an independent arbitrator. And in a few past years, I was the co-chair of a task force on disability inclusion in international arbitration. And I was curious if I could get any particular ideas you might have about cognitive diversity being enhanced by someone who, let's say, is cognitively diverse in the first place. So someone with ADHD who's bright, or someone, you can go down the list of the various things. I'm curious if that is just another example of how cognitive diversity could be enhanced, or is there something different or special there?
So I think that all different types of diversity, if we can say that, will bring different benefits, different perspectives, and I think life experiences. I think with the types of difference that you are talking about, they can bring particular abilities to empathize with minority viewpoints, for example, or to understand sensitivities which others might not. So I think there certainly is specific benefits that can be brought by those types of diversity, which contribute in general to the diverse differences, enhancing collective intelligence generally. But yeah, certainly important to include those too. Thank you.
Myrna?
Yeah. Yeah.
Hi, you're not Mary.
Hi.
I'm an arbitrator and mediator. Everything you said makes a lot of sense, but I'd like to sort of not push back, but let's talk strategy in real life. When a party selects their party-nominated wing, or when they're opining on the chair, they're not strategically looking necessarily for the right result. They're looking for the result that goes in their favor, right? And so, whereas everything you said makes sense for a right result, I'm not sure when we apply it to reality, really, just, it has its place.
Yeah, no, first of all, thank you for pushing back and representing a dissenting view to the theory I put forward.
Just by way of background, I'm not a litigator, have never been, but it seems to make sense if I were to be in that position.
Yeah, I've done a lot of research on the way that parties choose their arbitrator, and inevitably the bottom line is always we want the person who's going to give us the best chance of winning the case. As counsel, that's your job. But I think what I would say is that in almost all of the cases that I worked on, we wanted somebody who was a strong black letter lawyer, somebody who really understood the case and who would engage rigorously with the issues. There was one case where we weren't looking for that. And in that case, I might dispel some of the other considerations. But in general, people do want arbitrators who are going to really engage and read and understand their submissions and all of the witness statements and everything they've put before them. And so because the disputes that arbitration typically involves or engages with are so complex, increasing the collective intelligence of your group can only be a good thing. And that can only lead to your case being better understood, better discussed, more thoroughly discussed. So I think, in the minority of cases, you might not want a collectively brilliant tribunal, but most cases you will. Yeah, thank you.
So a question I have is, does this research point towards recommendation to counsel that when the arbitration agreement calls for a panel of 3, and the discussion is, well, we're going to save a lot of money if we just pick one person, that in fact more consideration should be given to the fact that with a diversity of 3 people, you're likely to get a better outcome. Is that, would you agree?
I hadn't considered that question, and again, sort of thinking back to my cases, the parties' likelihood of agreeing a sole where they should have 3 on paper might be tricky. But I think that certainly the benefits...
I guess, does the research prove to you that, generally speaking...
It's worth the money.
It's worth the money to have the 3-headed panel?
Yeah, I think certainly where you have a tribunal who are collectively intelligent and involving everyone in the discussion, then certainly all of the research shows that with those measures of turn-taking, of social sensitivity, you will end up with a better decision, a more thorough decision than one person operating alone. So yeah, that's certainly worth thinking about. Yeah. Yeah. Hi.
So with the curve you put up earlier showing how your CQ goes up first and then down again, how do we know when we have too much diversity?
Yeah, so I was thinking about that question as well, and just the impact of the implications of that graph, especially for tribunals where, let's say you have 3 nationalities that are wildly different, you've got not conflicting legal traditions, but different legal traditions, and it's difficult. I think, and the research that I show doesn't look at this because they looked at single groups doing single tasks. What I think would happen is that if you instructed those groups with a very high degree of difference on all of this work about turn-taking and the measures that can improve collective intelligence and performance, if they were instructed and they had systems and procedures in place, then maybe that curve might be less of an inverted U and more of an R. Yeah, that's what I'd like to think. To be tested. Yeah.
Thank you, Dr. Finch, for your presentation. You mentioned empathy when you were listing some factors for increasing tribunals' collective intelligence. I was thinking about empathy. Is it empathy towards other members of the tribunal or the parties as well?
That is an excellent question. It's, I think, all directions. So I think when parties are appointing tribunal members, they think, or they should be thinking, partly about empathy towards the parties. And I think if you do have empathy towards the parties and you properly understand the dispute and what the potential dynamics were in whatever conversation, that can be a very important way of properly understanding. But it's also really important, and the way I intended it on in this discussion was empathy with other tribunal members, particularly where you have that situation of a very diverse tribunal, and you really need to understand and get everyone's perspective, maybe from people who don't naturally kind of step forward, or who, when they express themselves, do it in a particular way. So I think empathizing with tribunal members, appreciating when someone might not be saying something that they could be saying, that type of sensitivity is really critical to reaching the best decisions that we've been talking about. So yeah, brilliant clarification though, thank you.
Paul?
Paul Fischauer. As most people probably know by now, I'm not a lawyer. I'm a non-lawyer tribunal member. I'm wondering, given that diversity is so important, have you looked at, and perhaps you talked about this early on, and I wasn't unfortunately in the room, at different kinds of diversity. So we have diversity of age, diversity of gender, diversity of background, diversity of experience. Have you considered the different kinds of diversity and whether some are more favorable than others? Or is it just you take it as it comes? And diversity
Yes.
is,
Any
ipso
diversity
facto
is
good.
Yeah. So honestly, the research isn't at that level yet where we've drilled down into the specific impacts of different types of diversity. Obviously, the collective intelligence research talks a bit about the impact of gender, which is positive. We just aren't at that sophistication level, I think, to be able to pin down exactly what different diversity levels bring. But we certainly are at the level where we can say any diversity is better than no diversity, partly because of that groupthink aspect, but also because different minds see different problems and different solutions. You will get a more comprehensive discussion if you involve lots of diversity. So yeah, we're not quite there yet. I will keep you posted on the research. Yeah.
Oh, hi. When I was looking at your presentation, it seemed to me that it falls into two categories. There's composition of the tribunal, and then there's practices that the tribunal can follow, and how they approach their decision making and how they approach their discussions amongst themselves. And it's almost like you can have a guide to sort of tribunal practices, regardless of how diverse your tribunal is. Am I thinking of it in the right way?
Yeah, I'd say that's right. There's like the substance and the functioning, I suppose. Certainly the kind of assets that I talked about, or at least the constitution of the tribunal impacts for all the reasons of diversity that we've talked about. I think the level of intelligence it displays can be improved by the procedures that we talked about. So I think we separate them like we do in this talk, but you would hope that the procedures would impact positively the cognitive intelligence asset at least. But yeah, I should write that guide. Thank you for that idea. I'll write that down.
And I think this will have to be our last question, so Robin.
Thanks. My name is Robin Dowdican. I'm a mediator and arbitrator in Toronto. This is a very interesting topic to me. From what you're saying, and sort of following up on what Craig said, it seems to me that the selection of the chairperson would be very important to make sure that all the voices are heard, because some people are very introverted and may not feel comfortable. So have you come up with a checklist or some tips for chairs of these panels?
I mean, honestly, I haven't yet, but I promise I will do that very soon after this talk. But you're right, the chair is such a critical role. And the best ones, for those of you who sit on panels, will know that they easily bring in everyone, ensure that everyone is heard. They have that ability to kind of facilitate communication. And it's it's coming back to that, one, communication, and two, empathy. But yeah, I think it takes very sort of complex and advanced social skills. I don't think you need decades of experience, actually. It's more the social skills, I think, that are important. But you're right that it's very important. I shall write that follow-up guide. Thank you.
We will look forward to that. So,
Thank
Dr.
you.
Cartwright-Finch, thank you so much for a fascinating topic. So now I will invite the moderator of the second portion of the TCAS program, George Karayannides, a partner at Clyde & Co. in Toronto, who's going to moderate the discussion with our two panelists, Laura Cundari and Peter Ashford, and George will introduce them. Thank you.
Good afternoon. While we in Ontario languish waiting on a new act, others have been busy. Welcome to our panel on recent legislative changes in British Columbia and the UK. We have two excellent panelists with us today, Laura Cundari and Peter Ashford. You've already heard a bit about Laura, but there's, I'm told, more, and I have it in front of me. Laura is a litigation and arbitration partner in Blake's Vancouver office. She's a fellow of the Chartered Institute of Arbitrators, the Canadian College of Construction Lawyers, the Construction Lawyers Society of America, and will be inducted as a fellow of the International Academy of Trial Lawyers next month. She is also a member of ICDR's Canada Advisory Committee and serves on the ICC Canada Arbitration Nominations Committee. She's ranked as a leading lawyer in a number of legal directories and was a recipient of the Vancouver International Arbitration Center's Excellence in Arbitration Award in 2023. Peter is an independent arbitrator, mediator, and consultant. And I think he made this up, but I'm going to read it anyways. He has been described in the directories as a doyen of the arbitration world, at the top of the tree, a legal mastermind, and one of the leading lights in arbitration. No, they really said that about him. He's also president of the International Arbitration Club, founder and organizer of the London Pre-Moot, and chair of the organizing committee for London Arbitration Week. Thank you both for being here with us this afternoon. Laura, I'm going to start with you. British Columbia went through a modernization of its domestic act in 2020. Can you give us a general overview of the act and how its structure and approach changed from the previous version?
Sure. So in BC, we had quite an interesting structure before we modernized. Our prior act provided that the British Columbia International Commercial Arbitration Centre, now known as the Vancouver International Arbitration Centre, VANIAC, who you heard from earlier, those rules applied unless the parties agreed otherwise. So as a result, there were a number of key arbitration principles and procedure embedded in those rules as opposed to in the Act itself. So it was quite a significant change for us when the Act was revised. The new Act is based primarily on the model law and fills a number of gaps that were previously in the BCI-CAC rules. The new Act also tried to align a lot more with the International Arbitration Act and international arbitration practice. And so the arbitration community, I think, hoped that this would bring more of an international arbitration style to our practice generally in British Columbia. And I think it has, I'm not sure that's the primary driver, but it's certainly, we're seeing that happen more general litigators adopting and embracing an arbitration, true arbitration approach. For example, there is a provision in the Act that talks about the presumption that evidence in chief will be in writing, and other provisions that align with what we all know as typical arbitration best practice. One other structural change was to move, we actually had family law arbitrations occurring under our Commercial Act, so those were moved out as well.
And what about appeals? Did BC adopt an opt-out or an opt-in approach? And were there any other changes to the appeal provisions?
So we went to an opt-out approach, but previously you could not opt out, so that was a big change for us. We used to have the same process for both set-asides, not the same process, but both set-aside and appeals were to our BC Supreme Court, and that was changed. So appeals go straight to the Court of Appeal, set-asides go to the BC Supreme Court, which I think maybe some of us don't love that, because you might end up with two different proceedings in two different courts as people try to sometimes attack an award from all sides. But the opt-out was a significant change for us, and something for those of us that advise on arbitration provisions that's important to consider.
Did VANIAC change its rules, given that they were formally designed to fill gaps in the Act?
They did.
Or designated?
Yes, so they did a rehaul of their rules as well. And also tried to provide sort of new features to the arbitration community to entice them to use those rules. So with the ability to opt out of the court appeal process, VANIAC has its own internal appeal tribunal that you can opt into, which is not used that much, but is quite a good feature that you can keep confidentiality and still have a second level of review if you like. They also developed expedited procedure rules, which have been very popular and I think really fill a gap in access to justice, and has also been great for giving newer arbitrators that first appointment.
Thank you. Any other specific changes that may have come to light or into creation with the new Act that you'd like to highlight?
Yeah, so VANIAC also was given powers as what's called a designated appointing authority. So as opposed to previously, you'd have to go to court to appoint an arbitrator if you couldn't agree, which if anyone's done that, it's not a fantastic approach. Now you apply to VANIAC for appointments, which is much more efficient. There were a number of things that were, I think, people understood to be the case, but there was some unfortunate case law that made things confusing. So consolidation was addressed more comprehensively, provisions around obtaining evidence, issuing subpoenas, things like that, interim relief, awarding equitable remedies, compound interest, and determining costs awards summarily. All of that was addressed, and I think we now have a good structure that doesn't leave a lot of those questions open to the courts.
Thanks. Now, Peter, a long drive from Vancouver and then across the pond, there's a new Arbitration Act in the UK that received royal assent in late February of this year. It has yet to come into force. A few questions for you. What impact will the new Act have on the law applicable to an arbitration agreement?
Well, that's a subject close to my heart. We had a case in the Supreme Court called Enker and Chubb, which said that in broad terms, the law of the arbitration agreement, being a potentially separable agreement, had to have its own law. That's completely orthodox. And they said, in general terms, it would follow the law of the host or matrix contract. So when a contract says this contract will be governed by the laws of England, that meant every single provision in there, including the arbitration agreement, would be governed by the laws of England. That created quite a few issues. It was wrong in my view. It should have been the law of the seat. And I had gone into press on this subject some years ago. And the Act, which as you say is not yet in force, says that in general terms, no, they switched it round. And in general terms, it will follow the law of the seat, which in my mind is far more logical, unless there's an express agreement otherwise. And what will constitute an express agreement otherwise is to be debated and to be decided by the courts. We that's to say, me and a number of other people, far cleverer than I am, proposed an amendment to the bill to cover off this point, to say that it had to be either expressly referring to the agreement to arbitrate or implicitly at least referring to it, but that wasn't adopted. There were quite a few late changes, and I'll come on to that in the opportunities missed bit, that weren't able to make it into the Act.
Thank you. And what about jurisdictional challenges and appeals? What does the future look like?
Well, the future is rosy, I think. We have 3 provisions in our Act about what we collectively call challenges. There's Section 67, which is challenges for the substantive jurisdiction of the tribunal. Section 68, which is serious irregularity causing substantial injustice. And Section 69, which deals with appeals. And I think we've had our very first case, but weeks ago, where they had the complete full house, and the court found breaches of each of those 3 sections, which takes quite some doing to get all of them. For those interested, if you look at my LinkedIn profile, the article is headed, "What Were They Thinking?" But just some stats on that. Under jurisdiction, under the commercial court who deals with these things, they had 24 applications, of which 1 was successful in the 23-24 year. Under Section 68, they had 37, 2 were dismissed, and 5 settled and withdrawn, so the rest were unsuccessful. And under Section 69, 52 applications, 10 granted and 21 refused, and the rest were pending. I know the appeal point is of interest to Ontarians. So our rule of appeals is that you have to satisfy 4 criteria. Firstly, it must substantially affect the rights of the party. Secondly, the tribunal must have been asked that question. Thirdly, it must be obviously wrong, or if it's a point of general public importance, it must be open to serious doubt, obviously a slightly lower threshold. And fourthly, it's just for the court to intervene, notwithstanding that the parties have agreed to arbitrate. So you have to satisfy all of those things to get an appeal off out. And we're an opt-out jurisdiction, so you can contract out of that right of appeal, and most institutional rules that we come across do indeed contract out. ICC, LCIA, those sorts of things, they all effectively contract out of that. And we didn't touch the appeals point. We thought that the Law Commission thought that the right balance was struck between award finality, which was perceived to be a good thing, and sort of quasi-endorsing something that is wrong as a matter of law. If you've chosen to have your disputes governed by a system of law, it should be decided in accordance with that system of law. So the Law Commission took soundings on that and felt that the balance was still about right. The changes, substantive ones, are to Section 67, the jurisdictional one, and that's really the process or procedure that's gone through. There used to be a rule under a case called Dalla in Pakistan where there had to be a full rehearing of all of the evidence. But now, if there's no new grounds of objection, no new evidence, that's the sort of Ladd-Marshall type test, i.e. couldn't have been obtained with reasonable diligence, and the evidence is not reheard unless justice requires otherwise. So we've sort of taken out that step for the court to have to rehear. It will simply look at the transcripts and the documents.
Thanks. And I understand that the new Act also addresses a tribunal's powers, and in particular with respect to summary disposal or dismissal. Can you tell us a bit about that?
Yeah, that's a codification of what I think many of us would have regarded as the tribunal's powers in an event, either through the general powers that a tribunal would have or under institutional rules. A lot of them say that summary disposal in some way is allowed. The LCIA submitted its 2023 statistics. There were 25 applications for early disposal. 3 were granted, 1 was partially granted, 17 were refused, and 4 at the date of the submission were withdrawn, suspended, or pending. So it didn't have a great uptick, and I think the philosophy behind introducing the statutory power is to put it on a statutory footing so that tribunals are emboldened to use the power. The test that is in there is no real prospect of success, either on a claim or defense, as the case may be. And the driver is time and efficiency, that it will actually make, if granted, a far more efficient process than not doing that. And again, it's not a mandatory section, so you can contract out. And if, for example, you contract out contract out by agreeing, for example, the LCIA rules, and because the LCIA rules, although they have a summary disposal, they have a different test, which is manifestly without merit. So you might think that the same test would apply, but it doesn't. So if you contract out in some way, by agreeing institutional rules, you may find you've got a different test. And then we'll have a nice debate about whether it actually means the same thing or not.
Next year. Now, the new act also imposes obligations on arbitrators. Do tell.
Yeah, this is the disclosure case after a case called Halliburton and Chubb, which again got to the Supreme Court, and is a perfect example about why a simple disclosure would have saved huge amounts of time and money. I understand anecdotally that Halliburton spent about 10 million sterling on the case. They did have a very high-powered legal team, but that's a lot of money in anybody's book to spend on that. And it was after a dear chap called Ken Rokerson, who was involved in 2 cases involving Deepwater Horizon. He knew that he was involved in both. Chubb knew he was involved in both, but Halliburton only knew about the one that they were involved in. So what the Act does is put into statutory form basically the findings that were in Halliburton, which is you need to disclose circumstances that would or might give justifiable doubts as to your impartiality. That's right, we don't have an independence rule in England. We only have an impartiality rule. That goes back a long time. We think that if people know that somebody is not independent, and it's the sort of village elder type decision, that's absolutely fine. If everyone knows that the village elder is not independent, what's the problem with him making a decision? There are problems with this, and again, I've gone into print in my critique on Halliburton. One of the things is it requires a disclosure of what you know or reasonably to know. But it doesn't say that you need to make inquiries as to what you ought reasonably to know. And again, an amendment was proposed on this, and again, didn't get adopted. So that simple thing that all of us do in our daily practice about making a conflict search is actually not part of the law. In Halliburton, they said, we don't rule out that it might be part of the law, but we're just not deciding it is, which is terrible. And you've got something called presumption, and that is from a case called Al-Mazidi, which went to the Privy Council, and whether a failure to disclose itself is prima facie evidence of apparent bias. And that's quite an important thing, and they discussed a lot about that in Halliburton. The other sort of problem with it is reputation, that it's a factor in the balance. So if you're Ken Rokerson and a man of extremely high repute, you'll be sort of trusted to get it right on the night type thing, which again I think is a very dubious concept. And finally, the issue is, when do you look at that? When do you look at the question of bias? And by the way, bias is not a pejorative sense. It's simply a lack of independence or impartiality. Is it when the court is seized of it and has to make its decision, or is it right at the beginning? And again, I think they got that wrong. But
okay. We unfortunately don't have the time to go over all that's new in the UK, but were there any opportunities missed with this new legislation?
Yes, there were. The first was that the Law Commission very sensibly took soundings and had received a lot of opinions. And in their first report and then in their final report, they annexed a draft bill. And lawyers being lawyers, it's only when you see the drafting of the actual bill you think, actually, that's not what we wanted, it doesn't work. And a number of us woke up at that stage and said, hang on, we want some amendments, and I've already mentioned a few. And the Law Commission's response was, if we do that, we're going to have to reconsult. And that's going to take too long. You either take it as it is, or you derail the whole thing. And so the first point I would say is, in terms of lessons lost, is get a draft out there and get dialogue going on it at a much earlier stage. The second thing they didn't address was confidentiality. It was just sort of something that they felt was better developed by case law rather than statute. It's a very fact-sensitive thing, and there's a very recent decision by David Foxton in one of those cases that's called, I think, A against B, but it may be another letter. That illustrates really quite how nuanced the question is, and probably, therefore, rightly, it's not part of it. They didn't discuss third-party funding and artificial intelligence, which, again, I think are better developed in soft law or institutional law guides and that sort of thing. It's a fast-moving process, not really suited for statute. And corruption was the last one that had quite a lot of excitement around it. We had a case called Nigeria, or PNID in Nigeria, where an enormous award, I forget the numbers, but it was very big numbers. And it was found on challenging the award that actually all the Nigerian team had been bribed, both to get the contract in the first place and for the process of the arbitration. The tribunal couldn't quite work out why Nigeria were being so inept in putting their arguments, and the answer was they were being bribed to throw the case, basically. And the lawyers involved on P&ID side all got reported to their regulators. So it was a very unhappy thing and caused lots of consternation. The thought was, can we do something in the Act to sort of beef this up a bit? And I confess that I drafted the amendment, although I hasten to add I didn't believe in it. I didn't think it needed to be done. But a good friend of mine in the House of Lords, again, it's another matter, but wanted to propose something and said, Peter, can you come up with some wording? So I did. He spoke in the debate in the Lords, and he was challenged by Lord Hoffman, who's a very famous judge, now arbitrator, who sat in PNID, who absolutely wiped the floor with him, who said, what do you think the tribunal should have done? Well, ask a few more questions, perhaps, red flags and all that sort of stuff. But again, that didn't make it through.
Thanks. Thank you both. I think we have time for a couple of questions if anybody in the audience has any. All right, who's going to win the game tonight? Mr. Horton.
Okay, I'm gonna this one. I'll ask a question to which probably nobody else wants to know the answer, just to kick things off. For the purposes of Section 69 and appeals, are foreign law, where foreign law is an issue, is foreign law considered to be a question of law or a question of fact for the purposes of Section 69?
It's a fact. All foreign law is a fact.
All right.
In English parlance.
Okay, even
so
under the appeal
it'll be done in that way.
Okay,
Yeah.
thank you.
And just while I've got the floor, anyone who's really sad and is interested in this in any more detail, I've written a new ARB brief on it, and it's published on the CanArb website. So if you go to the megaphone thing, you can find a slightly enlarged version of what I just said.
Anyone else? Well, thank you very much. Oh, wait. Oh, we have... Nope, wait. To my left.
Only to thank George and Laura and Peter for this panel discussion, and again, Dr. Cartwright-Finch for a fascinating discussion. Thank you all for attending, and enjoy your coffee.